Good afternoon, everyone. Unless you are on the West Coast, good morning still. Thank you for joining us for the next session of our GovCon 101 series. Today, our expert instructor is Chris Wade. She'll be covering government property for the next 75 minutes. If you have any questions related to government property, feel free to ask that in the chat. Chris will be able to address that for you directly. If it's anything PCI related, passwords, certificates, anything like that, my name is Josh, and I can help you out with that in the chat as well. If you haven't had a chance to download the materials already, the materials are available in the materials tab. You'll find a PDF version of the slide deck Chris will be going through today. We're not going to have any passwords as this is a GovCon 101 training. So this is free to join if you are seeking credit and you don't already have a subscription to GovCon 101 One Stop or the anything else that would allow you to receive a certificate for this training. Please reach out to us. My email is joshpina@publiccontractinstitute.com. You will receive your certificate of completion automatically from GoToWebinar 24 hours upon completion of the training. So around 2:15 p.m. Eastern tomorrow. For CPE, CLE, CLP, anything like that, feel free to reach out if you have any questions. Chris, without further ado, it is all yours.
Thank you. All right, so today we're here to talk about GovCon 101 government property. So far, part 45 is what we're going to focus on. This is an introductory course, so we won't be able to go through everything in copious amounts of detail. But what we hope to do here is give you a good understanding of the two main families of government property, where the requirements for government property administration can be located, an overview of what the government property lifecycle is, and how different contract types can affect the property that you have in your possession. And so without further ado, we'll go ahead and get started. Okay, so the main question is, what is and isn't government property? So it's a little bit different in the Title 48 federal government contracting world than it would ordinarily be if you just looked up property in Merriam-Webster's dictionary. Property in this sense, under Part 45 of Title 48, it means it's all property to which the government has some sort of interest in. So it could be real or personal property. It includes any material, equipment, tooling, or special test equipment. So it refers to government property to which the government has a vested interest in, so title, either vesting or they own it outright already. And it comes in two main families. It comes in acquired property and furnished property. One thing to note is that government property in this sense, and what we're talking about today, it does not include intellectual property or software. That's addressed under Part 27 of the FAR. So if you're looking for information about that, that's where you go to this. So this is tangible property. It's property that you can physically touch. So nothing that exists in the ether would be categorized under government property in this sense. Comes in two main families, government property. There's acquired property and there's furnished property. Furnished property, sometimes it's called GFE, GFP, could be referred to as GFM if it's material, but a lot of times it's just referred to as GFP. And the idea here is that it's property that the government owns and that they're going to let you, the contractor, use, or a contractor use. So if I'm the contracting officer and I have some property that would benefit the execution or the performance of a particular contract that a prime contractor has, I can furnish that property to that contractor for use on that contract. Typically, it's furnished without fee, meaning there's not a rental or usage charge. Sometimes there are rental fees or usage fees, but most of the time with government furnished property, it's given to a contractor in whatever condition it currently is, and it's for the use by the contractor on that contract, and then the contractors to return it back to the government when the contract period of performance is complete or when you no longer have a use for the property on that contract. Contractor acquired property is the second family. That's the sibling, if you will, to government furnished property. And what it means is, it means that it's property that a contractor acquires, so they purchase it, or they purchase the materials and they create something with funds from a federally issued government contract or contract vehicle. So it means that if you receive a contract, let's say from the Department of Defense, or Department of War, and you are to fabricate a widget with funds from that contract, and you purchase material and you deliver that widget is, and the materials that you bought in order to fabricate that widget would be contractor acquired property. You acquired items using federal funds, and then you're going to deliver it to the government at the end of the contract, or when it's no longer required on the contract. So in essence, what it's the main difference is, one, the government is issuing the property to you and you'll sign for it. You'll be the steward. The other, the contractor's purchasing the item, and then the government will eventually own it. So those are the two main families of government property: government furnished and contractor acquired. Now, within those two families, you can break it down a little bit more, and you could have material, equipment, special tooling in both government furnished property or contractor acquired property, right? And so you can break it down even further into categories that fit into those subcategories of each family of property. And so typically what you'll have is property that's expendable or property that's non-expendable. Durable property is property that's in the non-expendable class. So non-expendable property are items that are not consumed during their life cycle. So expendable property would be items that are consumed, or they lose their identity during the course of their life cycle. So the easiest way to explain expendable property is items that are consumable. So for example, I buy a big vat of chemicals that I'm going to use on a plating line or something like that. I'm going to use those chemicals, and at the end of whatever I'm using the chemicals for, there will be no chemicals left. They will be consumed. They'll be utilized during whatever process I'm using them for. Another example of a consumable item are screws, nuts, bolts, fasteners. These are all things that are going to lose their identity during the course of their life cycle because they're going to be incorporated into a higher end assembly. If you're making a car, you're going to have nuts and bolts that are going to get incorporated into that car to hold it together. At the end of the day, you'll have a car, but the individual items, those nuts and bolts, are going to lose their identity, and you'll just look at the car as a whole. So those are two examples of consumable items. Non-expendable items are items that retain their identity for their life. So a car that retains its useful identity, your laptop, a desktop, a monitor. These are all things that might have consumable items in it, but these are the major end items that you might buy material for, create something, and then that end item is a non-expendable item because it retains its identity. A lot of times these are things that are serialized, so they have serial numbers attached to them, indicating that they're unique, specific, and they're not going to get consumed into something else. Now, durable property, as I mentioned earlier, is a form of non-expendable property. It's a subcategory that some subdivisions, particularly in the Department of War, they use Army. It's items that don't necessarily have book value accountability because they're not high price, they're lower dollar items, but because of their nature, they're durable. And so it would require accountability if they're marked as D for durability. An example would be a hammer. A hammer in and of itself might not be very expensive. You can go to Home Depot and purchase one. Maybe it's $20, something like that. But it's going to have a useful life of more than a year. And so a lot of times it'll be marked durable because it has a useful life of more than a year, but it's a very low dollar value item that might not require proper book accountability otherwise. So certain items you might see marked D, they're durable, they need to be treated as non-expendable property with book value accountability. So those are the two main families and categories of property. You have furnished property, you have accountable property, and then within those you have property that's consumable or expendable, it'll lose its identity, or you have items that are durable and non-expendable, and that they have a useful life of a year or more, and they require book value accountability. So now let's talk about where these things are identified under Title 48 in the FAR, and where we find the requirements on how we're supposed to account for property, report on property, administer property. And that's all in Part 45 of the FAR. So Title 48 is the federal regulations, specifically the federal acquisition regulations. It deals with any contracts that are issued with appropriated funds, so meaning funds that Congress appropriates and passes and approves budgets for. And Part 45 is one of the subparts of the FAR. And so specifically, Part 45 addresses government property, both furnished and acquired. And so we're going to hit on a couple of the main sections of Part 45 that are important for identifying responsibility, liability, property management system, reporting requirements, and a couple of key clauses. One thing to note is that most of the sections of most of the parts in the FAR, they're all kind of organized the same way. If there's definitions that are unique to the particular part of the FAR that you're looking at, those will be listed first. You'll then have a section on policy, you'll then have a section on general, and then you'll have specific information that's relevant to that particular part of the FAR. Definitions in general are in FAR Part 2. So what you'll find is if there's definitions that are unique to a particular part of the FAR and they're not listed in 2, they'll get incorporated into that particular section. So Part 45 is no different. It identifies what the definition of government property is, and a couple other definitions. You can find that in 45-101. Okay, so what is the policy of the federal government as it pertains to government property? First and foremost is the expectation of the government is that contractors are required to come to the contract fully prepared to furnish all of the materials, all of the property necessary in order to perform that contract. So what does that mean? It means if I'm performing a service contract that my staff are going to come, they're going to have laptops, they'll have, MFA devices on that to make sure the laptops are secure. If there's special software they'll need, they'll come with that software. They'll have everything they need, pens, pencils, papers, etc., in order to perform that particular contract. So that's the default position, is that the government will not furnish anything to the contractor. The contractor will come prepared to perform the contract. However, in some cases, the contracting officer identifies that it's in the government's interest for them to either furnish property to the contractor for use on the contract, or allow the contractor to procure items, purchase items to be used on that contract. And so the government will then identify any property that will be furnished or any items that can be purchased by the contractor during the solicitation phase. And that way, everybody who's competing on the particular solicitation for the contract has equal opportunity to understand what's being furnished and what's not being furnished, so that it's a level playing field for competition. For example, if an incumbent knows that they were furnished a particular piece of testing equipment, for example, it would be an unfair advantage for that incumbent to not then go price that special test equipment or something in the solicitation if they know the government's going to furnish it to them. So during the solicitation phase, if it's in the government's best interest, the government will identify what property can either be acquired or will be furnished on the contract. But before they do that, the government has to identify and specifically document that it is, one, in the government's best interest to furnish that property or allow the contractor to acquire it. The overall benefit of furnishing the property or allowing the contractor to purchase it outweighs the increased administrative costs of monitoring, auditing, assessing the property that's in the contractor's possession, including final inventory reports and final property assessments. That Furnishing the property or allowing the contractor to acquire it does not increase the government's risk. So it has to be risk neutral or a decreased risk on the government's part. And then finally, the government's requirements for the contract performance cannot otherwise be met without either furnishing the property to the contractor or allowing the contractor to purchase it. So internally, the procuring contracting officer has to document answers to all of these things prior to allowing any contractor to have government property on their contract. All right. So we know that the policy is that the government says you have to come prepared. We're not going to give you any property, but in the event that property is allowed, they'll document why it's going to meet those 4 items we just talked about, and it's in the government's best interest to do it. So what is the expectation of contractors that have property, government property, on their contract? So first, the government says, hey, you know what, contractors, you don't have to create a special system just for federal contracting and just to deal with the property on your contract. You can use voluntary consensus standards. And what those are is it's industry best practice. What's industry best practice for asset management? They'll allow you to leverage the industry best practices that already exist and then incorporate some additional requirements into your system. I'll say small S system. So your property management system. That could be people, processes, tools, technology, whatever it might be, all together that forms your small S system. And so examples of voluntary consensus standards or industry best practices comes from places like ANSI or the National Property Management Association. Both of these industry organizations issue best practice documents, guides, requirements for handling assets, asset management, and the life cycle of property in general. So is it unique and specific to government property under Part 45 in the FAR? No, but it is industry best practices. So if you as an organization are already leveraging these best practices, you just need to layer on the requirements of FAR Part 45 on top of the system that's already working for you. So again, to that point, agencies will not require contractors to establish a property management system that is separate from a contractor's established procedures. So if you have a system in place, an asset management system, a property management system, and you're new to federal contracting, you would just need to overlay the additional requirements to that system that's already established within your organization. Okay, so FAR Part 45-105, Contractor Property Management System Compliance, states that property management systems are required to comply with contractual requirements. So that means that any requirements specific to your contract are going to be expected that you comply with. Frequently, there aren't separate instructions in your contract, but what will be in your contract are certain clauses. And so by incorporation of certain property clauses, you're going to be required to comply with the requirements that are established in FAR Part 45. To verify compliance with the requirements that are identified in FAR Part 45, the government can perform what they call PMSAs, Property Management System Assessments. Different agencies have different procedures for how they perform these assessments. However, DOD established, DCMA specifically has established a property guidebook that has been updated substantially over the last 5 years. I want to say about 5 years ago, 6 years ago, it was less than 28 pages, and now it's about 150 pages. So it's quite a detailed guidebook that provides best practices and rules for handling property in your possession. So from a government perspective, a lot of the other agencies will leverage that guidebook as a tool for the assessments that they perform as well. And this specific guidebook identifies 22 specific elements that are part of the property life cycle. manual, and it describes the elements and what's required pursuant to FAR Part 45 or the agency supplement, and provides instructions on what you're supposed to do with it and how you're supposed to comply with those requirements. That's on DCMA's landing page. If you go to dcma.mil, you'll see it listed right under the CPSR procurement manual. So sometimes you're going to have a separate, sometimes you'll have multiple contracting officers involved with your contracts. Sometimes you'll just have one who wears many different hats. But in theory, you could have a procuring contracting officer, you could have a contracting officer who administers the contract, and you might even have a separate property administrator. So that's a PA that would consult to the contracting officer, either the procuring contracting officer during the solicitation phase or the contracting officer after contract award. The PA is required to notify the contractor in writing whenever a non-compliance is specifically identified with regards to a contractor's property management system. The contractor then has the ability to correct the deficiency, create a corrective action plan, submit it, and then ultimately have that deficiency resolved. However, it is a requirement within Part 45 that if a deficiency is identified, the CO or the PA, whichever you have on your particular contract, is required to notify you of that deficiency, and it has to be in writing. All right, let's see.
Hey, Chris.
Yes.
We do have two questions. The first question was, are cables considered expendable / consumable property?
Tables, T-A-B-L-E-S?
Cables with a C.
Oh, C. So typically cables, yes, they would be considered consumable because they lose their identity once it's connected to multiple servers or what have you. So yes, they're not serialized. They typically have a useful life of a year or less. And so typically, yeah, cables, unless it's a very specific kind of cable, would be considered a consumable item, yes.
All right, and the second question, I guess there's actually two questions now. The second question is, can you provide a link to the guidebook?
Yes. Yeah, it's dcma.mil, but I can provide the link too. Yeah.
And then will you repeat what PA is again, please?
Yes, PA is property administrator.
That's all we have for now, Chris. It's all yours. Thank you.
Okay, very good. So we are on transfer. Okay, 45-106, transferring accountability. So I mentioned earlier that property can be furnished, right, or acquired for use on a particular contract. Notice the wording that I'm using, on a particular contract. So if you receive property from the government, if it's furnished to you, or if you acquire something, you can only use that property on the contract to which it's identified. So even if you have 3 contracts with the same agency and you receive property on contract A, you cannot use that property on contract C. You can only use the property on contract A. Now, you can transfer property with the government's approval by modifying both contracts and transferring it that way. And I think I have a diagram that we can go through later, but yeah, I'm not seeing it here. So the way that happens is you would mod both contracts. The government will modify contract A, and even if the item doesn't physically leave your facility, let's say you have a facility floor where you manufacture items, you might have that item and it might stay on your facility floor and you might not physically return it. However, what happens in essence is when the government modifies contract A and removes the property, you're virtually transferring that property back to the government. And so that government then will transfer again that property to contract C through a modification to the gaining contract. So one's a losing contract and one's a gaining contract. And so that's how property can transfer from one contract to another. Ordinarily, if there's a benefit to a contract that you have in your possession. When you do your inventory and your property disposal reporting at the end of the contract, you can identify the government if you can repurpose that property. And if the government doesn't have a different need for it, they might let you go ahead and do that through this process. So the main thing here and what you need to understand is that if it's government furnished property, it's pretty straightforward. The government will add property or award the contract and list the government furnished property on that contract. When you're done using the property, the government will mod the contract and remove the property, and then can mod that receiving or gaining contract to add it onto that. The government retains title to the government furnished property at all times. However, if you're going to transfer property that starts as CAP, so contractor acquired property, then when you virtually return the CAP to the CAP turns into government furnished property because you've now delivered it to the government takes possession, and when the government reissues it to the gaining contract, even if it's still your contract C, it'll be issued as government furnished property on that gaining contract. So that's a unique occurrence that happens when you transfer CAP from one contract to another. So I mentioned that a lot of times your contract won't actually have a list of government property requirements in the contract itself. But what it will have is the basic property clause. And this basic property clause includes all the information that you'll need in order to administer and report property in your possession throughout the life cycle of your contracts. And so the main clause is 52-245-1. So it's important that when you look at a solicitation, if you see this property clause in the solicitation, the expectation is likely that either government furnished property or contractor acquired property will be utilized on the subsequent contract award. And what this property clause identifies are all those requirements. So it's used on all different contract types. You can have this clause in here. You can have it on fixed price, solicitations and contracts, cost type, T&M, labor hour, all different kinds, including commercial item procurements, meaning Part 12 commercial item procurements under the FAR. And the guidance is in subsection 45107A. And so this clause defines what government property is. It identifies what the property management system is, how you can use government property, what government furnished property is and how you can use furnished property, and then title to government property. So both government furnished property as well as CAP. And it goes through in a lot of details and lays out all of those requirements. So this is the basic clause. And if you see this clause in your contract, then chances are you're either going to be purchasing something that is considered government property, or you're going to be furnished government property in that particular contract. Now, there's an important alternate to the basic clause found at 52-245-1. Alternate 1 is considered the full risk of loss clause. And it's important that if this is included in the solicitation or your contract, that you pay very close attention to it. So ordinarily, the government understands that life happens, okay? And so they will not put the burden of risk on the contractor and make the contractor responsible if something's stolen, if there's an act of God and the property is destroyed, things like that. Now, if you're willfully negligent, then yes, you will be held accountable. But if you're not found to be negligent and something's lost or something's broken or it's destroyed by an act of God, the basic clause says, we understand life happens. You're not going to be responsible for it. You'll just have to notify us through the proper reporting requirements and avenues, and you're not going to have to pay us back for it. However, if the alternate 1 clause is included in your contract, that means the contractor is fully liable for the property that's in their possession. And so that's very, very important, because if you're going to have substantial property in your possession on the contract, at the time of solicitation, you may want to consider purchasing insurance to protect you from the loss of that property if something should happen to it. So that's a really important alternate one to a clause that you need to pay attention to at the solicitation phase and then also at contract award. Additional clauses that are may come up in your contract includes your government property installation operation services clause and then your use and charges clause. This really only applies when there's going to be property on government installations. So if you're not dealing with that, then this probably isn't going to come up too often for you. The use and charges clause, however, if you recall at the beginning of the session today, I said that most of the time government furnished property is issued without fee, without a use and charge fee. When 245-9 is included in the contract, then sometimes the government is going to charge a rental fee or a usage fee to the contractor in order to use the item that's going to be furnished to the contractor. And so it requires ACO approval. And interestingly, you don't pay this fee to the agency under which your contract is let. When you're having a use and charge fee assigned to your contract, you actually submit your payment directly to the Treasury. So it doesn't even go back to the agency or the sub-agency to which the contract belongs. It goes directly to the Treasury Department. So when you have this clause in your contract, that's a good indication that you may very well have fees associated with the property that's on the contract. Typically, this is special test equipment or large pieces of machinery that require some sort of maintenance and calibration. And so to recoup that maintenance and calibration cost, the government may charge a use and charge fee so that it can properly be maintained. It's not usually small dollar items. It's items that are usually special test equipment or tooling or things of that nature. Now, there's another clause for you folks who are DoD contractors, so Department of War contractors, or any of their agencies. There was a change a couple of years ago to the DFARS clause, or DFARS clauses, I should say, that apply to government property. So under Title 48, you have the federal acquisition regulations, and it has all the parts. So 53 parts plus CAS, so Part 99 as well, 54 in total. And then you have agency supplements. So Chapter 1 is the FAR itself, but then starting with Chapter 2, each agency can have a supplement that cannot conflict with, but adds additional detail to the FAR, right? And so DoD is no different. They have the Defense Acquisition Regulation system. And these DFARS items include property clauses. So there used to be several property clauses as it relates to the DFARS supplement and what you're supposed to do with property in your possession when supporting these DoD contracts. However, as of January of 2024, they were consolidated. And so now you have a single clause, which is 252-245-7005, management and reporting of government property, instead of 4 other clauses that were specific to contracts issued prior to January 2024. Now, if you have long-term contracts that are 5 years or more, or several years at base plus options, it's possible that you still have the legacy clauses, these other 4 clauses in your contract, and they'll be in effect until your contract is either modified to incorporate the updated clause and remove the old clauses, or until it ends. Those will be grandfathered in. All right, so let's talk about, yes.
Sorry, before we do get to this next section, we had a few questions.
Okay.
Regarding the guidebook, someone said they were not able to find it. This is the DCMA guidebook for GovCon property administration, correct?
It's property guidebook, yes.
Is the latest
share my screen, so I'll send the link after the class.
Is the latest version from May 2024? Are you aware?
No, I think there was an October 25 update. It should be on the website, but I'll check after the class. I can't recall what the last revision date is.
Okay, I have a May 2024 version, so I'll look for a newer one. If I am able to find that, I'll upload it to the materials for everyone.
Perfect.
We do have a few questions. I'll just bring up a few of them. Because we have such a huge audience, we might not be able to address all of the questions till the very end. But the next question I have here is any property bought under a cost plus contract considered government property, or does the government property clause need to be in the contract?
Good question. So there's a thing called the Christian doctrine, and the Christian doctrine, it was a lawsuit, and essentially what it says is if a clause should be in a contract, but it's not because of an error of a contracting official, you should consider the clause to be in the contract even if it's not there. So if you have a cost type contract and it's for more than just services, okay? So you have any kind of CLIN that would allow for any kind of material purchase that's not just labor. So any kind of ODCs or anything like that that's other than labor. You should consider that the basic clause 52-245-1 is in the contract, even if it is not. Now, if it is only for services and it's a cost type contract, you will not have typically the basic property clause there because there's no CLINs for anything to be purchased on. Now, title is a little tricky, so we're going to get to that in a couple of minutes here. And instead of hopping around in the slides, I'm just going to pause the rest of the answer to contract types and title because we're going to hit on that. And I think the actual slides might be helpful to explain it. What was the other question?
The attorney did say thanks. That's what they were looking for in reference to the Christian doctrine. Kind of based off what you just said, we do have a few more questions, but I think it might be hit on in the slide deck. So if you want to just,
I'll just keep going and then we can hit on them at the end. Okay.
Yes, ma'am.
Okay. So let's talk about the acquisition life cycle or the life cycle of government property. I mentioned earlier there's property considerations that the contracting officers have to take into account during the solicitation phase, the pre-award phase. But then there's certain things that have to happen after contract award as well. And then there are things that happen for contract closeout. So if you consider the life cycle following a pre-award administration closeout kind of trajectory, you can see that these items in this diagram here all fit into that. So government furnished property or contract acquired property, it'll be identified during the solicitation phase. So you'll have your pre-award phase over here, and then at some point the contract's going to be awarded. And at that point, you're either going to have the government furnished property listed on the contract, or at some point you might actually have to go ahead and purchase some contract or acquired property. So then there's going to be reporting and record keeping requirements, right? So you're going to have physical inventories, you're going to have records of the property that you purchased, you're going to have receipts, you're going to have periodic reporting. And at all times during the property life cycle, any property that's in your possession, you have to be mindful that you are the steward of that property until you are formally relieved of your stewardship. And so that's identifying in your property records who's physically in possession of that government property. And that includes subcontractor control as well. Any property that you allow a subcontractor to have in their possession, you are still the steward of that property, even though you allowed the subcontractor to have it. The prime is always going to be the steward of the property that is in a subcontractor's possession. There's reporting requirements, there's utilization and maintenance records, calibration records that have to be maintained on certain kinds of property. And then there's property closeout activities, either when the property is no longer required or at the end of your contract. So this is an overview of the property life cycle in general. So again, the pre-award phase, this is where the contracting officer, sometimes with help from a property administrator, they're going to coordinate what kind of property might actually be required on this contract. And they'll include that kind of information in the solicitation itself. And they'll specify any responsible party for costs of making the government property available, including transportation, installation, or rehabilitation costs if necessary. So if there's time phase property requirements, the dates when the property will be available for use will be included. If there's any use and fee charges or use and charge fees, the 52-245-9 clause will be included in there, and the amount of rent or fees will be identified. And if you're going to need to have a property management plan, those requirements would all be included in the solicitation during that pre-solicitation phase. So what's the contractor's responsibility? Well, when a property management plan is required, a special plan does not have to be created, as we mentioned earlier, for government property that's used on a specific contract. You can use your industry best practices and the property management plan that you already have in your possession. You just need to tailor it to the requirements of FAR Part 45. And 52-245-1, that's your basic property clause. In Section B, it specifically says the contractor shall initiate and maintain the processes, systems, procedures, records, and methodologies necessary for effective control of government property, consistent with voluntary consensus standards. So again, you can rely on industry associations like ANSI or NPMA and leverage those voluntary consensus standards, those industry best practices with regards to creating your property management plan. So in the post-award phase, this is where most of the property administration is going to take place. This is where you'll have records, you'll be demonstrating accountability, you'll be doing your reporting, you'll be maintaining stewardship. All of this is going to happen in that post-award phase during the administration of your contract and maintenance of your property in your possession and the property management system. So we mentioned before how you can transfer property, right, from one contract to another. In the post-award phase, this is how property actually comes into your possession. So a contractor can get property either by having it issued from stock by the government, it could be leased by the government, or it could be transferred. And we talked about that in modding the losing and the gaining contract. So it can be transferred from the government to a contractor, from one contractor to a completely different contractor. If one's the incumbent and they're outgoing and there's a new contractor coming in, you could have property transferred that way, or it could be transferred from one contract to another contract within a contractor's organization. So this is the diagram I was looking for before when I was talking about the losing contract and the gaining contract. And so in a contract to contract transfer, when it's within the same contractor's organization, you'll have that losing contract and the gaining contract. And so if on the losing contract you had CAP, contractor acquired property, when you virtually transfer it back to the government, even if it stays at your facility, it's going to transition to government furnished property. And at that point, when the government mods that gaining contract within your organization, that will be GFE. It'll no longer be CAP. If you have GFP and then you're transferring that GFP to another contract, it'll always stay as GFP. So how does a contractor get property that's not furnished by the government? This is going to the cost type contract question that someone asked previously. So CAP is contractor acquired property, and property obtained via purchase by the contractor to which title of the property will vest by the government. That's considered government property, okay? And title and vesting is different on fixed price contracts than it is on cost type contracts. So on fixed price contracts, the contractor will retain title to all property acquired by the contractor for use on the contract, except if the property is specifically identified as a deliverable end item in your contract. Conversely, on cost type and other flexibly priced contracts, like the M portion of a T&M, the government acquires title to all property to which the contractor is entitled to reimbursement. So it's a matter of whether or not you're going to get paid for it. So let's dig deep into this a little bit more. So government retains title to all government furnished property. That's just period. Doesn't matter if you have a cost type contract, a fixed price contract, If it's government furnished property, whether it's GFM, materials, special tooling, equipment, whatever it's going to be, if it's GFP, the government always retains title, okay? Until and unless they disposition it for abandonment or something like that. So this includes property that is leased by the government and furnished to the contractor for use. Title is not affected by its incorporation into or attachment to any property that's not owned by the government. So let's say the government says, I've got this giant special grinding machine, right? And I'm going to let you, contractor A, use this machine because it's very specialized in order to perform certain things at your facility. So the government furnishes this grinding machine to the contractor. The contractor receives it. The contractor then bolts the grinding machine down to the floor on their shop at their plant. Just because it is affixed to your floor does not relieve the government of title to the property. The government still has title to that property. That will always, it's government furnished property. Title is always going to remain with the government, and you will have to give that grinding machine back at the end of your contract or when it's no longer required. So the government just always retains title. That means ownership of property that's government furnished property. Now, title to property for contractor acquired property is a little bit different. Title to each item of equipment, special test equipment acquired by the contractor for the government under a contract shall pass to invest in the government when its use in performing the contract ends or when the government has paid for it. So on cost type contracts, any flexibly priced contract, so cost type, T&M, either when the use of the property in your possession is complete, the CAP, or after the government has paid for it. So regardless of whether the government has the property in their possession, if the government reimburses you for that property on a cost type CLIN, title then begins vesting in the government, not with the contractor. And then the government will have to receive that property at the end of the contract or at the end of the use of that property, whichever comes first. So title will vest, which means it's almost like a hold. So the government's ultimately going to get title to it. It's considered vesting until they receive that property into their possession. And so, as we mentioned earlier, fixed price contracts, the key is the deliverable end item. So let's say we have a fixed price contract for $1.2 million. It's 1 year long. And we have a deliverable listed on the contract that we have to deliver a testing apparatus. And it's listed as a deliverable. So during the course of this fixed price contract, I purchased some materials, some adhesives, some nuts, some bolts, some circuit boards, some computer chips, maybe a balance or a weight system. I buy a whole bunch of stuff. And some things you have to buy in packs. Let's say metal. We have to buy the metal, iron or steel in sheets. You buy multiple sheets of metal, and I have to buy these special nuts and bolts in packs of 100 each or something like that. At the end of the contract, I have half a sheet of sheet metal left. I have 75 nuts or bolts. I've got a few circuit switches. I've got some computer nodes or something. I've got some things that are left over, but I did create the apparatus. So the apparatus itself, title is vesting with the government in that apparatus on this fixed price contract. And I have to deliver that apparatus to the government because it's listed as a deliverable on my contract. However, the 75 extra screws, the extra anodes, the half a sheet of steel, all this extra stuff that I purchased on this fixed price contract in order to create this apparatus, which is a deliverable listed in my contract, all of that extra stuff is mine, the contractor. Title is not vesting to the government in that extra stuff. It's mine. It's a fixed price contract, and I do not have to disposition it because it's not listed as an end item. They didn't say as the deliverable that all material associated with the apparatus, including any nuts, bolts, anodes, blah, 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 circuit switches, motherboards, etc. They didn't list that as a deliverable. They said the apparatus is the deliverable. So anything left over is now mine, the contractor's inventory, and you can do with it as you see fit. You can put it into inventory, you can use it on another contract, you can throw it away, donate it, whatever you want. That's a fixed price contract. However, if it's a cost type contract and you're building the apparatus, every nut, screw, bolt, anode, everything is the government's. And so at the end of the contract, you have to list all these items, and the government will disposition the items and tell you what to do with it. They might ask you to mail it back to them. They might ask you to scrap it. They might ask you to donate it, to trash it, to do all different things. But cost type and T&M contracts, the government has title vesting with anything that you got reimbursed for. Very much different on a fixed price contract. And so it's really important to understand that. Let's see here. I think, okay, fixed price contract. So when does title pass to the government? If title's vesting in a particular item that's listed as a deliverable on the fixed price item, the title will formally transfer upon delivery or upon issuance of the property for use in contract performance. So in the apparatus scenario I was using, if I have to develop this apparatus and then use it, once I start using the apparatus, that's when title will formally pass to the government, even if that apparatus is still in my possession. Otherwise, when I deliver it to the government, that would indicate title will pass to them, and relief of stewardship would go from the contractor, and the new steward would be the government once they receive it, or upon commencement of processing the property. So submitting your invoice for the deliverable and sending the deliverable to the government. So that's when you'll formally transfer that vested title to the government for that item on a fixed price contract. As I mentioned before, contractors are entitled to reimbursement as direct items of cost, sometimes referred to as ODCs, under a cost type CLIN. And once you issue that property for use or you're reimbursed by the government, then title is formally transferred to the government for that property that you purchased. Okay, so let's talk a little bit about some post-award phase things pretty quickly, and starting with inventory. So there's a couple of key points when you have to do inventory of property on your government contracts. At the contract start, you always want to do inventory of anything that's being furnished to you with the contract. You also want to do inventory at the end of the contract, and you want to periodically do inventory during the course of a contract. If there's an outgoing contractor and an incoming contractor, sometimes you'll do joint inventory, but it's important that you not only identify that the items that are being included in your contract are in fact where they're supposed to be and available for use, but you have the right metadata related to the property that is being furnished to you. So you want the manufacturer number, you want any serial number, you want the condition of use. That's very important. If you are to receive furnished property in order to perform your contract, and it's supposed to be in a certain condition of use, so fully functioning, minor dents, something like that, and they give you a piece of property and it's not fully functioning, it requires maintenance or something like that, that's considered a delay until the government gives you the furnished property in the condition that it's listed in the contract. So it's very, very important that you identify not just the inventory that you're receiving, the furnished property that you're receiving, but the condition that you receive it in as well, because you'll be required to give it back in the same condition minus wear and tear that's expected for that item. So inventory of government property should be based on the requirements within the contract, your property management policies and procedures, so the contractor's property management policies and procedures, the type of property that's in your possession, is it furnished property or is it CAP, and how the property is being used. If it's critical or sensitive property, it needs to be treated separately. But essentially, if your property management procedures internally say, we do wall-to-wall inventories of everything in our possession once a year, then that's what you're expected to do. If you say we do sampling 4 times a year, that's what you're expected to do. At the very least, though, inventory should be conducted no less than annually. There are standard forms, inventory reports that can be used. A lot of different agencies use different forms. They're all in FAR Part 53 SFs. I have a list of them, a couple slides down for you. But typically an inventory report will reconcile what you're supposed to have with what you actually have, explain any overages, underage, any items that are lost. If they're lost or stolen, you'll have to do what's called an LTD&D, or used to be LTD&D, loss, theft, damage, and destruction report. For DoD contractors, that happens in PI. Now it used to be forms. For other agencies, they still use standard forms frequently. You need to include the name of your property contact in the report, your contract number, and then you need to make sure that you include in your inventory report any property that is in a subcontractor's possession, because you submit one consolidated report because the prime contractor is always the steward of the property. Roles during the post-award phase, I think we talked about this. There's the property administrator, which is government, the contracting officer, the PA and the contracting officer may or may not be the same person. And then typically you'll have a program manager on the contractor side, or the program or project point of contact, who's kind of the lead main point of contact for executing that contract, or for identifying any issues or concerns or performance, that point of contact, that liaison with your government customer. Okay, property disposal. Property disposal happens prior to the contract closeout phase as part of the contract closeout process. It requires that between starting about 120 days before your contract is physically complete, that you have to do an inventory and submit to the government what's called a disposal schedule. And so the basic clause provides the approval and disposal processes, as well as the timelines that the government has to receive the disposal reports, identify any corrections that need to be made, get it back to the contractor so that the contractor can then follow the disposition instructions that's provided by the government with regards to the property in their possession. Now, 45.6, FAR Part 45.6, it talks about reporting, reutilization, and disposal. And there's certain timeframes that the government has to perform certain activities once an inventory disposition schedule is received from a contractor and approved by the government. That means it's complete, they verified it for accuracy. That starts the clock ticking, and the government has about 45 days to identify whether or not they can reutilize the items within their agency, whether they have another part within their agency that could use the item, whether it needs to be disposed of, donated, scrapped, what have you, or if they have no use for it within their agency and they're going to send it to GSA to see if GSA can use it someplace else within the government, and if not, then it gets put up for auction within GSA. But it's a very strict timeline, and it's all laid out in FAR Part 45.6 regarding after they receive the disposition schedule and it's accurate, so the government approves it. That's when the clock starts ticking for the contracting officer and the PA with which to go ahead and disposition the property that's in that schedule. We talked about title to property, post-award phase, I think. Okay, so the status of government property, both CAP and GFP, has to be maintained in your inventory and record keeping software, spreadsheets, whatever you're going to use. that includes the status of the property that's in your possession. So you have to not only identify what it is, right? So the serial number, the model, manufacturer information, the condition that it's in, but you also have to identify who is the steward, so who is it issued to, who's responsible for it, what is its physical location and place of use, that has to be tracked. If there's any maintenance that's required for the item, specifically any special tooling equipment, test equipment, other equipment, your maintenance has to be fully documented and maintained in your records for that item that's in your possession. If it's removed from use and placed in storage, you need to declare it as excess and identify that. If it's ready to be retired or disposed of, you need to keep track of the dates that it was identified in any forms or reports submitted to the government documenting those items as well. Reutilization. Okay, disposal methods. Let's talk about that. So the contractor is not allowed to dispose of any government property, CAP or GFP, until the government authorizes you to do so, and you have to follow the instructions the government provides you. So the most common disposal method, so you submit your inventory disposition schedule to the government says, okay, this is accurate, I'm accepting this, I'm approving this, here are your disposal instructions. So the government will typically abandon the property in place. This is only, this can only happen with the contractor's confirmation. So the government is not allowed to abandon property at a contractor's facility without the contractor agreeing to have the property abandoned there. It has to be in writing. And the government is not allowed to abandon any sensitive property. The government can instruct the contractor to try to sell it as surplus property. They can instruct the contractor to dispose of it as scrap. Or they can ask you to destroy it. So demilitarization. So at that point, you take a sledgehammer to it, you drill holes through the laptop, whatever you can so that its useful form is no longer viable. There's special requirements for disposal of contractor property outside of the United States. I'm not going to go through those. It's special instructions, but you can see if you go to your agency supplements, there's specific instructions on how to do that as well. So inventory disposal reports. The most common is the 1424, that's standard form 1424. All your standard forms are in FAR Part 53. So if you go to acquisition.gov, you click on the FAR, you go to Part 53, you're going to have all your standard forms, and that includes the 1424. This is the form that's historically been used across all agencies that identifies and provides disposition instruction for property. There are, in different agencies, they'll use different forms, and they might have a preference for one over the other. But here are some of the most common standard forms that you can report on excess property. So even though it says personal property, it's talking about government property. So at the time when you identify that you have property that you no longer need on a particular contract, you don't have to wait until the end of the contract. In fact, you're required to report that excess property to your PA or contracting officer. And if they don't have an online platform like PI for the Department of War, they might use something like the standard form 120. They might also leverage a 1423 or 1424 for inventory verification or disposal reports. There's also the 1428 for inventory schedule. Again, different agencies rely on these forms, especially if they don't have an online automated system, but these are your most common standard forms that you might encounter with regards to property disposition. Okay. Contract closeout. So before you can close out a contract formally with the government, that's called an administrative closeout, you have to conduct a final inventory of all the property that's in your possession. So property inventories are required, even if there's no property on a contract. You have to positively say that no government property, neither CAP nor GFP, was, involved or used in the performance of this contract. You have to positively state the negative in order to go through the administrative closeout process. It's on a checklist, and the government cannot close the contract until the property is fully dispositioned. And so the final inventory needs to cover all the property under the contract, including all the subcontractor property. It needs to include all of the expendable and non-expendable property and its current status. And so what do I mean by that? For non-expendable property, you'll identify its location and where it currently is. For expendable property, you're going to identify whether or not it's consumed or whether there's any still remaining. On a fixed price contract, mind you, that any item that is not part of and deliverable item would not show up on this report. So particularly for cost type contracts, you're going to disposition everything that you purchased on the contract or was furnished to you on the contract and its current status. And for those expendable items, you would itemize those as consumed if they were in fact fully consumed. And then the non-expendable items, again, you would list its current location, so that you can get disposition instructions on where to ship it to or what the government wants you to do it. You need to include any lease credits for leased properties. You need to include, if it's contractor acquired property, the number of units that you acquired and the unit price for all the items, as well as the disposition status of all of the items procured. Any failure to provide a final inventory will result in a delay of contract closeout. As I said, it's a required part of the contract closeout. The government can hold final payment on your contract if you do not provide your inventory report. So it's very, very important at the end that you do this. In certain cases, when you have hazardous materials, you may be required to provide a decontamination certification or other kind of certification for those types of materials that they were properly dealt with. If government property is going to be transferred to another contract, you can do a joint inventory. Also, if you have a need to use the property that's currently on one of your contracts on another contract, in your inventory disposal schedule that you submit to the government, you can identify alternative purposes of use on that contract, including using it on a different contract. So that's a boon to the contractor, being able to self-identify additional uses of that property. If the government terminates your contract, termination inventory is the same thing as a final closeout inventory. So it doesn't matter if it's terminated early or not, still the same as normal contract closeout procedures. In addition, you have to provide disposition of the property, where it's located. I talked about that. Disposal options for cost reimbursement contracts. So if there are items that are not consumed on cost type contract claims, and you include those items on your disposition schedule, the government can allow the contractor to purchase the CAP from the government for 100% of the acquisition value. So that means if I bought a laptop for $1,500, it's, I don't need it anymore, the government the government can say, okay, I'll allow you to buy back this laptop, but it's going to be at the exact same price that you purchased it new. So the contractor has to agree to buy the CAP back. The government can't just require you to purchase the CAP back. That's an important nuance there. The government can ask you to return the item to the original supplier or the OEM for credit, less the restocking charge. So, hey, I got this at Amazon. Let's see if I can return it to Amazon. And then you apply a credit to the contract. They can ask you to transfer all or part of the inventory to another contract, whether it's yours or a different contractor. If it's inventory for leases, they can ask you to transfer the leases or return it. For HHS, a lot of times HHS will ask you to return the inventory to them directly, so just ship it back to them. And then identify any inventory that's excess in that disposition process. So again, the government has those 45 days once they receive that proper schedule so that they can figure out internally what they're going to need to do with it. So just finishing up here, I did want to mention that inventory reporting, government property reporting, for Department of Defense, Department of War contractors. It used to be called IUID and PCARs. The systems, these are all now located in PI, the Procurement Integrated Enterprise System. Same thing that you do your invoices for these DoD contracts. It's under the property management section of the program. PCARs is now done, so the plant clearance automated reutilization screening system is actually in the GFP module, even it's called GFP. It's in the GFP module, even though it's CAP. And then the government furnished items are still in the IUID module, so on the IUID registry right here. We only have a couple minutes left, and I want to make sure that I hit on a couple of other items before we finish. IUID data requirements. This is a specific section in your basic clause. D, E, and F speak to IUID data requirements. If you are a manufacturer, you are required to create the IUID prior to delivering the items to the government that they are purchasing. And it is a specific sequence that includes your cage code, along with the date, the number of items. It's a special sequence number that you create with contract metadata and your corporate information that you have registered in SAM. So if you're a manufacturer, I highly encourage you to look at D, E, and F in the basic clause for your IUID requirements as well. And with that, Josh, I'm gonna stop here and see if anyone has any questions or if there's any questions submitted that I didn't already answer.
We do have a few questions from earlier. Sorry, I guess I haven't spoken in a while, so my voice sounded kind of scratchy there. I'm going to put up some of these polling questions that we have first, just for anyone who is seeking credit so that we can maintain eligibility for that. Our first polling question, these are all going to be true or false here. Agencies will not generally require contractors to establish property management systems that are separate from the contractors. So I believe we have 3 total true or false questions. Chris, if you just want to briefly go over the answers, we have 90% true.
That's right. So yes, agencies allow contractors to use voluntary consensus standards, their own industry best practices for creating their property management system. You do not need a separate property management system specific for the government. You just need to overlay the requirements from the FAR, the agency supplement, that apply to your contract. Are you there, Josh?
Indeed, I am. I was not aware that I had muted myself, so sorry about that. So for this one, we have 90% true.
Which one was that?
That was a contractor is not permitted. Let me see if I can share it again. A contractor is not permitted to dispose of any property, CAP or GFP, without the government's written consent.
That's right, true. Yes, the government has to approve your disposition schedule and provide you instruction as to how they would like you to dispose of it.
And then our final polling question before kind of our ratings poll there is the full risk of loss clause does not hold a contractor liable for loss of government property, true or false? Again, after this question, which we are leaning about 83% towards false here.
That's right. So yes, the full risk of loss clause is alternate 1 of the basic clause 52245-1. And if you have that, that means as the contractor, you will be liable. You will be held liable for any loss, theft, damage, destruction, anything that happens to the property that's in your possession.
Thank you so much there, Chris. So that was our final true or false kind of trivia question there. We do have our final poll up now, which is just please rate this session. Excellent, very good, good or fair. If you are seeking credit for this training and you did not already request it as CPE or CLP through the $45 accreditation fee, or if you're not part of one of the bundles, please feel free to reach out to me, joshpina@publiccontractinginstitute.com. And now I'm going to get into the questions. So for anyone who has kind of a hard stop at 2:15 p.m., you're free to go. You even got an extra, I guess it's 2:15 now, so no extra time back there, but you are free to go. The first question I have here is, has there ever been a circumstance when government property is used concurrently on multiple contracts?
Yes, that's a good question. So yes, what happens is there is a responsible contract. So let's say you're a contractor, okay, contractor Alpha, and you have 3 contracts all with the same agency, and you have a potential use of, let's just say it's government furnished property on two of those contracts at the same time with periods of performances that are running concurrently. One contract will be the owning contract, the responsible contract. So the property will be issued to, I'm going to say contract A. But in contract A, there will be specific instructions that allows use of this piece of equipment or property, whatever it is, on contract B. Contract B will not be the responsible contract for the property. However, contract B will either be modified or have written into it that use of the particular piece of property that belongs to contract number, whiskey 912 dash whatever, can be used also on that other contract. So there's still only one responsible contract, one owning contract, but another contract can have almost like a lower tiered status with the ability to use that piece of property on that contract as well. That's a great question.
Thank you, Chris. The next question I have here is, does the transfer of property include badges such as common access cards, tax? Do you need a modification? Yes? Or no? Okay.
No, tax are not property.
Perfect.
Neither are items that are incidental to performance. So things like tables, chairs, a cabinet, those are things that are considered incidental to a location. So those aren't considered property either.
Who pays the personal property taxes on GP or GFP?
So GFP is government furnished property. So if there is any property tax, the government would be responsible for that. However, the federal government is usually exempt from federal property tax. CAP, however, depends on the state. So different states have different sales and use tax exemptions. Not every state exempts federal procurement purchases from property tax, sales and use tax. If you're talking about property tax, like a county might levy on your car, that is county and state oriented as well. And whether or not there is an exemption to that would be handled by the state as well. I believe most states allow for a federal exemption of sales and use tax. I'm not aware of any property tax. I guess if a contractor purchased something like an automobile under their contract, and the state had a property tax, you would have to look at the property tax laws for that particular state in order to see if the property tax applies to that federal car, because the contractor wouldn't own it. It would be CAP. But for sales and use tax, it depends by state. Most states exempt federal exempt federal government contracts from sales and use tax, but not all do. I'm pretty sure Maryland does not. That's one that's coming to mind, but I know there's many states that do.
Okay, we have a few more questions, Chris, so thank you for staying on. Thank you for everyone for staying on as well. When a prime contractor includes 52.245-1 in the subcontract as a flow down, how is that treated? What is the practical effect?
Okay, so first of all, yes, absolutely flow that down to your subcontractor if you intend to allow them to have any property on their contract, either if you're going to allow them to procure items, you definitely need it, or if you're going to issue them a piece of furnished property that was issued to you. For practical purposes, they're required to have the entire same property management system that the prime contractor is required to have. The only main difference is that the prime contractor is going to be the steward of the property. So ultimately, the subcontractor has to do all the same reporting requirements. They have to do all the same inventorying. They have to do all the same record keeping, and they need to routinely furnish that to the prime contractor so that they can incorporate and update their system with that information as well. However, it's in terms of loss, theft, damage, destruction, liability, it's the prime contractor who's the steward of that in the eyes of the government. So, so that's the only difference. But as a prime contractor, you want to make sure that your subcontractor has a fully integrated, implemented property management system so that you're monitoring them and that you're decreasing risk of any loss or negligence that could happen with the property in their possession, especially because you are the steward of the property that you allow them to have.
All right, we have a few more questions here. I'll get to maybe one or two more. The rest of them I can send to you offline, Chris, and we can kind of address those because we're already some 6 minutes over. Can you please explain the manufacturer's responsibility for creating the IUID? Why and when must it be created?
So if you're a manufacturer, the basic clause is going to be in your contract. Also, there's going to be an IUID clause in your contract and specific instructions for the IUID in there. And there's several guides. It depends on the agency that you're working with, but there's a specific sequence. I can see if they let me know what agency they work with, I can try to find the information for them. But it's if you're working for DoD, you can't. When you submit an invoice, you have to create the WAF record, the wide area workflow record, and the creation of the IUID is part of the WAF processing. And so you won't be able to submit your shipping and receiving records in WAF and then and then invoice the government for it until you create that IUID number in the system. I'm not sure how other agencies handle it. I know that DoD, it's part of the whole WAF process in PI and in those modules. If they could share what agency they're working with, I can see if they have several instructions, but and I can try to pull down a guide for them on how to do it. But typically your folks who work in accounts receivable, they're going to know how to do the WAF records in order to create those IUIDs and then implement them into the system.
Chris, she did respond and said it's DoD.
Okay, so yeah, so it would be in PI. It's part of the WAF process, and there's a specific module where when you're creating the WAF records for review and acceptance by the government, that you would create the IUID. And so I can see if I can get a guide for that to get it out to them.
Thank you. And for the last question that I'm going to put out here, it's kind of a multi-part question, so I'm going to try to combine them as it's multiple messages here. The first part is we currently only have subcontracts with several primes. We often buy special tooling that is included as specific line items in our subcontract. This almost always becomes USG owned property. When would that normally occur? When we purchase it and invoice our prime customer, or would it be capped until used on a follow-on contract? And then they have an additional question here, sorry. Also, our contracts are almost all fixed price contracts. If we procure tooling, would our vendor need to assign the IUID?
So the prime contractor is the only one that can assign the IUID because it's tied to their contract and their cage code. So whoever's the prime is going to be responsible for creating the IUID. If you have fixed price contracts and the items are listed as deliverables, then the items will vest as CAP that the government will own, will have title to ultimately. If it's not listed as a specific deliverable item, then those items would not be considered cap or vest with the government. So on fixed price contracts, title will transfer either upon delivery or upon payment for the deliverable that you submit.
All right, thank you, Chris. Thank you everyone for joining us today. There were a few additional questions, Chris. I'll send those over to you, and I'll make sure that the appropriate attendees get those questions answered.
Okay, very good.
Thank you so much, everyone. Have a great rest of your day.
Thank you.